Ms. Kinsler, if you'd like to begin.
Thank you, Your Honor. A little background on this case. There was an original order in suit affecting the parent-child relationship. And it was John David White II and Gloria Aisha Khalik. That order was entered on March 15th, 2017. In November 2020, Noah's grandparents, John White and Sandra White, filed a petition to modify requesting conservatorship of Noah due to concerns regarding his emotional well-being and physical care. There was a hearing on November 6, 2020 in front of Judge Hathcock, where they were appointed the sole managing conservators. After that time, there was an agreed order of withdrawal for Ms. Khalik's counsel that was signed on May 3rd, 2021. In that document, there was an email address and a address in which we were supposed to send final trial, all notices. So as we sit here today, we have sent out a notice of final trial to both the email address that was listed in the order of withdrawal that she had signed it, and that we believe is her email address, although she's never responded. And we have sent the notice of final trial to that address.
Let me stop you for a second. You say you believe you sent the email to Ms. Khalik's, what you believe to be her address. Why do you believe that to be her address? Is it the address that was listed in the order permitting her former counsel to withdraw?
Absolutely, Your Honor. So there was, and do you mind if I share my screen, Your Honor?
Not at all, please do.
This is the agreed order of withdrawal. There is no email address listed in the body of this document. However, when you go to the e-service, I have an email address of this email address that was circulated to her. So in addition to sending the notice of final trial and the other documents to the physical address, we've also been sending it to this email address that was included in this document.
Thank you. That answers my question. I see that in your notice of final trial setting that you filed with the court on August 24th of this year, your certificate of service says that you served her via certified mail, return receipt requested. Did you get a green card back?
We did not get a green card back. And let me again share my screen. And so this is the notice of final trial that I'll submit as petitioner's exhibit 2. This was the notice. We sent it to the email address here. And then in addition to that, we got the unable to deliver.
Does it say why? Does it say no?
It says insufficient address, unable to forward.
Well, you didn't have, hold on. You don't have an apartment number. Doesn't the order on withdrawal have an apartment number? Am I wrong about that?
It does not have an apartment number.
Okay, I'm looking at it. It doesn't. All right.
It doesn't. And so we have, I don't know if you can see this. This is now going up blurry. Of all the attempts to try to communicate with Ms. Khalik over different issues, these have all been returned to us.
Did you, when you're mailing her certified mail, did you also send it regular mail?
We did, Your Honor. Okay. Yes. And I want to, again, want to be very transparent. We don't believe that she's living at that address anymore, but we don't know where she's living. She's been exercising possession of Noah, the child at issue, but the parties meet, and sometimes she'll send her brother, she'll send other people. She's not updated us with her address. She's not updated my clients with her address. That's one of the issues in this case, is that she moves around regularly. Again, this is such, when you have grandparents coming in and trying to meet this burden, that's why I'm telling you all this. to see if there's anything else that you want us to do to try to.
My question based on what you just said is, I wonder, did anyone, when she comes to exercise her possession, has anyone attempted to give her any of the notices or?
We have not, Your Honor. I have not taken that extra step.
Well, I don't guess you are not required to, but okay. Go ahead.
So I think we've complied with what we've needed to under, I guess, getting her notice. The biological father is sitting right next to where it says John White. That should be John White and John White II. So Noah's biological father is here, and I believe he's going to consent to our requested relief as well.
Okay, go ahead. You may proceed.
Thank you, Your Honor. And since we went through all this, I would ask the court to take judicial notice of the address in the agreed order for the motion for withdrawal, or that document. I would also ask the court to take judicial notice of the certificate of the respondent's last known address and the non-military declaration that is in the file that were filed on September 25th, 2023.
The court takes judicial notice of the agreed order on motion for withdrawal of counsel filed on May 3rd, 2021, which states that the respondent mother, Gloria Kalik, address 57. I will also take judicial notice of the certificate of respondent's last known address filed on September 25th, 2023, showing the same address, as well as the non-military declaration filed with this court on September 25th, 2023. Okay, you may proceed.
Thank you, Your Honor. I would like to call Sandra White. Are you retired as we speak now?
Yes, I'm retired from Child Protective Services.
Okay, and prior, how long did you work for Child Protective Services before your recent retirement?
37 and a half years.
Okay. You have one son, is that right?
I have two sons.
Okay. And what is the name of your son that is in the courtroom today?
John David White II.
Okay. And did John David have one child with Gloria Kalik?
Yes.
And how old is Noah?
Noah is 11 years old.
Okay. Was there a court order regarding Noah that was reached between your son, John David, and Miss Kalik on March 8th of 2017?
Yes.
Your Honor, I ask the court to take judicial notice of that order.
So noted.
And you and your husband were not listed or mentioned in that original suit affecting parent-child relationship, correct?
Correct.
Okay. Where is Noah currently living now?
He lives in my home with me and my husband, John White.
And where do you all live?
We live in San Antonio, Texas.
And do you all own that home that you live in?
Yes.
Okay. And when did Noah start living with you all?
Oh my goodness. He's been living with us on and off since he was 2 years old.
Okay. And when did you go back to court to get an official court order that he would remain living with you?
In March of 2017.
And did you and Mr. White have a temporary orders hearing in November of 2020, where Noah was ordered to live with you all?
Yes.
Okay. And in 2020, when you and Mr. White filed a motion to modify and request to be appointed the conservators to take care of Noah, what was going on at that time with Miss Kalik?
She was unstable in her housing. We never knew where she was living. Noah reported to us at times they lived in a car. We believe that she was under the influence. She had recently given birth to a child, and that child, when they did a test, tested positive for meth. She was also having some mental health issues.
Okay. And during the course of Noah's kind of childhood leading up to that, had there been different men coming in and out of Noah's life as well?
Yes, several several men that she had reported to us or Noah had told us about.
Okay. You mentioned that the baby had tested positive for meth. Do you know if CPS is still involved in Miss Khalek's life and regarding her other children?
No, I do not.
Has CPS not been to your house since the court order appointing you and Mr. White conservators of Noah?
No, we were what they would call a safety placement for him. And once they found out that we were seeking custody of him, they closed their case on us. So they did not continue contacting our home, but they were making monthly visits up to that point.
Okay. And Your Honor, if I could have you take also judicial notice of the temporary orders in suit to modify parent-child relationship that was signed in November of 2020.
So noted.
Thank you, Your Honor. And Ms. White, I'm going to show you that document just for reference. And under the temporary orders from November, was Ms. Khalek ordered to have supervised possession of Noah?
Right.
Okay, and this is the provision regarding supervised possession. The people listed in it were Courtney Fierro, John Fierro, or Josh Armstrong. Are any of those people still part of Miss Khalek's life?
I don't think the Fierros are a part of her life anymore. Josh has also had some mental health issues, and so their contact has been sporadic.
Okay. Additionally, under this court order, Ms. Khalek was ordered to submit to drug and alcohol assessment and psychological evaluations through the Texas Department of Family and Protective Services and Child Protective Services. Were you updated regarding the results of any of that?
No.
Also under this court order, Ms. Khalek was ordered to continue to see a psychiatrist and therapist. As far as you know, has she continued to seek that mental health treatment?
No.
Now, how often has Ms. Khalek been seeing Noah since this court order has been put into place?
We have kept our part of the court order and meet her twice a month on the weekends at the Bucky's at New Bonneville to exchange Noah. There have been times where she has not exercised that right and called us and told them that she couldn't have him for the weekend. And so we have kept him with us, and that's occurred several times.
Okay. Has she been involved in any school or medical decision making for Noah?
No.
Okay. When Noah has come back from possession with Miss Khalek, have you noticed any behavioral changes in Noah?
Well, I mean, Noah started to get very nervous and biting his nails to the quick. And so we had to take him to his PCP to see what we could do to help with that. And she recommended that we take him to a therapist to deal with that. And so we did secure a therapist for him. And we saw him for about 8 times and felt like he was doing better. And at school, he would act out. And so we have the school counselor involved, and he's also in group sessions with the counselor at school. So we continue to provide that for him to help him to deal with some of his issues about his anxiety.
What drug of choice does Miss Kalik like to use?
I'm not too sure, but at the beginning, she was also involved using prescription drugs also.
In addition to methamphetamines?
Correct.
Okay. And can you tell when Miss Kalik is relapsing or using drugs again?
Yeah, we can tell just by her behavior. She becomes very sporadic and then doesn't have the visits like she needs to, or she acts erratically at times.
At the time in 2022, when CPS got involved, Miss Kalik had a new baby at that time. Is that right?
Correct.
And are you aware or have you seen that Miss Kalik is currently pregnant again?
Yes, she is pregnant again.
Now I want to go through I'm going to show you our proposed disposition of issues of what we're asking for today, so we can so you're asking today that you and your husband be appointed sole managing conservators of NOAA. Is that right?
Yes.
And that you have the final exclusive decision making regarding NOAA.
Yes.
And you're although you're asking for sole managing conservatorship, you're agreeing to a geographic restriction of the state of Texas.
Yes.
Okay. And for the possession schedule, you're proposing that Miss Kalik have possession every second and fourth weekend of the month, beginning at 6 and ending at 6 p.m. That she would have Mother's Day weekend and then some time over the Christmas holiday. Is that right?
Yes.
And the possession that you're proposing over the Christmas holiday does not allow time for Miss White, or I'm sorry, for Miss Kalik to have Christmas itself. And why is that?
They really don't celebrate Christmas. She's Muslim, or she has been practicing your family. So for her, Christmas is not a major holiday for them.
Okay. Additionally, for possession, you're asking that her possession be supervised by an agreeable third party, or if you're unable to agree, someone who's listed on the Travis County Kids Exchange Network. Is that right?
Yes.
And who has been supervising possession as we speak now, since those three providers have not really been in the picture?
I don't know.
Okay. And what is your concern with not having any access to supervised possession?
Because honestly, we just don't trust what she tells us, and because she has moved around so much, we don't even know what her current address is, and at times we find that she's left in with her brother or her father during the weekend, so we don't know.
Can I ask a clarification? So she's exercising possession with a supervisor you don't know. You're allowing her to do that?
Well, yeah, simply for Noah's sake.
And Miss White, when Noah comes back to you, who is he normally around in addition to Miss Kalik?
When he visits her, or
Yes.
She's currently has someone we think she's gotten married to. He has 2 other siblings in that household, her father and her brother.
And so a lot of the times when she is exercising possession, are her father and brother around as well?
Yes.
Okay. When Miss Kalik is not using drugs, do you have a concern regarding Ms. Kalik having possession of Noah?
I don't know how to answer that, but I don't know for sure.
Why don't you want to cut off Ms. Kalik's possession to Noah completely?
Well, I think, Noah has that strong bond to both his mother and father. And, we do observe and talk to him, after visits and before visits. And I think there's been 1 or 2 times where he's called us to come to pick him up early because he didn't feel good or he just wanted to come on home. And so I think that Noah can let us know that, if things are not going well, that we'll be there to pick him up. He trusts us to take care of him.
If we go to unsupervised possession, what would be your concern going forward if you have concerns that Ms. Kalik is using again?
Well, I think, just the supervision and the care that she provides for him. But if we have, custody of them, we will be able to pick them up. Whereas before, when we didn't have custody of him, she didn't allow us to get him. And so that's why we even entered into a legal agreement.
Okay. In addition to possession for Ms. Kalik, you are also proposing that your son have possession first and third weekends of the month, beginning at 6 p.m. on Friday and ending at 6 p.m. and then Father's Day. Is that right?
Correct.
Okay. And then the holidays, do you normally spend them with your son and grandson?
Yes, they usually come over to our house and spend part of their holidays with us.
Okay. And so you're asking that you have the holiday time, but that if Mr. John David White II would like to exercise some holiday possession, that you all are going to work that out?
Yes.
Okay. And at this time, you are not asking for any formal child support from either your son or Ms. Kalik, is that right?
That's correct.
Okay. And why are you not asking for any formal child support from Ms. Kalik?
Because I feel like at this time, it would be a moot cause with her. She hasn't provided any support up to this point. And so I'd rather not have to deal with that. I have good medical, dental, eye insurance that Noah is under with us. And so that would continue with him.
Are you and your husband able to financially provide for Noah without state assistance?
Yes.
Okay. And also in our requested relief, we originally asked for, you are going to continue to carry Noah on your insurance, but any unreimbursed medical expenses, you are requesting that your son and Ms. Kalik reimburse for 50% each?
Yes.
Okay. And we did originally request for attorney's fees, but based on your son and Ms. Kalik's financial situation, we're not going to move forward with that request at this time. Is that right?
That is correct.
I'm going to pass the witness at this time. I don't know if you had any questions for Ms. White.
I have questions. Maybe it may be more appropriate for you, Ms. Kinsler, to answer. I've heard Ms. White's testimony, all of which seems reasonable, especially in light of the temporary orders that have been in place for several years. My question is, if the exchanges are going to be at the grandparents' house in San Antonio, which is reasonable, but why would you say if they can't agree on a supervisor, she has to get a supervisor from the Travis County Kids Exchange? Are there going to be any Travis County Kids Exchange supervisors that'll go to San Antonio?
Absolutely, Your Honor. I think if it gets to the point where there needs to be a Travis County supervisor, I think Mr. White and Mrs. White will make sure to come to Travis County to do that exchange. I was just trying to list a specific supervisor so that if things arise in the future, everyone has that fallback order. And At this time, my understanding is Miss Kalik is in the Austin area, but sometimes she was in Dallas for a bit. She was in New Braunfels for a bit. She's kind of all over the place.
No, I get it, and that's fine. I just wonder if you say that she has to pick up and deliver from the grandparents and they're in San Antonio, is any supervisor going to be willing to do that?
Absolutely. I know a few will travel. I don't think it's the ones through Kid Exchange. So if I need to go find some in the San Antonio area, I can absolutely update that order for us.
No, I mean, I think it's fine, but since you've said if it comes to that, the grandparents would be willing to drive to Austin for an exchange, why don't you just add it to your order? And it's fine to continue to use the Travis County Kids Exchange if you add that.
Okay, I'll update that, Your Honor.
Okay. That was the only real question I had. Other than, well, let me ask Miss White, how is Noah doing in school?
He's done so much better since living with us. He's had to do some tutoring in his math and reading, and he was really behind in his reading and had to have a resource teacher. But now he's on target with his reading, which we're very excited about. He is in a chess club after school, and he's also in a science club after school. So he's thriving, and the counselors keep us up to date along with his teachers who has annual ARDs. And so we just want to ensure that he just continues to progress because, we're extremely proud of the progress he's made. So
well, you should be. Thank you. Thank you, ma'am. Ms. Kinsler, you have anything here?
Nothing further for Miss White.
Okay. You want to call your next witness?
Yes, I'd like to call John White. And you heard everything that your wife just testified to regarding Noah. If I asked you all of those questions, would that be your testimony as well?
Yes.
Okay. All right. And that's all the questions I have for Mr. John White.
Thank you, Mr. White. Ms. Kinsler, what else do you have?
Now I'd like to call John David White II.
Put your hand down.
You've heard the requested relief that we're asking today for Noah. Is that your agreement for Noah?
Yes, it is.
And why do you think that it's in Noah's best interest to remain with your parents?
I just believe he's progressed so much. I think having him with my parents has just made him better. It's gotten him to where he trusts, he wants me around. He likes seeing being around my parents. And I agree with everything that, y'all talked about just now.
Okay. I'll pass the witness, Your Honor.
Thank you. Thank you, Mr. White. All right, Ms. Kinsler, anything further?
That's all, Your Honor. I sent your office a proposed order outlining everything that we've requested, but I will go back and make that one change for the kid exchange and then get that back to you.
Okay. Having heard the evidence, I do find that the requested relief is definitely in Noah's best interest. And I want to take a second to thank Father for being willing to let Noah have a safe and place to live with your parents. And I especially want to thank the grandparents. I don't suspect when you guys got ready to retire, you thought you'd be raising another young one, but I'm happy to hear about Noah's progress, his extracurriculars. And I just want to thank you again for the time and the effort you're putting into making sure your grandson is raised up to be a happy, healthy, and productive citizen.
Thank you, Judge. Thank you.
thank you.
Thank you all very much. Ms. Kinsler, I'll look for that revised order. As soon as you get it, I'll get it to a bench. I believe this is Ms. O'Donnell's motion for contempt. Is that correct?
Yes, ma'am.
And this is your motion that you filed on August 21st, 2023?
Yes, ma'am.
All right. Anything pretrial, or are we ready just to begin with opening statements and evidence, whatever evidence we need?
I'm ready to begin.
Ms. Bass?
I'm ready, Your Honor.
Okay. All right, Ms. O'Donnell, if you'd like to begin.
Yes, Your Honor. Thank you. I'm asking the court to consider the facts and evidence that I'll be presenting today that is going to show that Mr. Shepard is in contempt of court. I'm asking the court to find Mr. Shepard in contempt, and in doing so, reinforce the final orders by ordering Mr. Shepard to reimburse his total debt in full immediately, as well as order Mr. Shepard to reimburse me for the additional interest I have now been paying on the debt that he still owes me. And then also reimburse me the additional costs that I've had to pay for today's hearing. I'd like to begin by bringing to the court's attention a couple of inaccuracies in the respondent's answer that was filed on October 4th. Line item 3 states that the respondent has paid me to date since the last hearing $700. To date, Mr. Shepard has actually paid a total of $600. This information was actually provided to Ms. Bass via email, her response to her email asking me how much her client has paid me. I do have a copy of that email that I can provide if need be, as well as the proof of payments that Mr. Shepard has paid me via Venmo is uploaded as evidence as Exhibit G. Also under item 3, it states that the respondent has paid all of the previously ordered reimbursements of $753. The $753 consists of a $360 credit card balance transfer fee that I accrued, as well as $393 in court costs for previous hearings. Again, Mr. Shepard has only paid $600 of that $753. Therefore, the answer that the respondent filed, if it was accurately stated, should say that Mr. Shepard has paid $600 towards the balance and still owes a balance of $153, as well as 50% of the child's defense attorney. So I would like the court to make note that the answer that they filed is not accurate.
This is just opening where I want you to tell me what you're seeking and what relief, and we'll need to get into evidence about that.
Okay, no problem. So just to go back to my original, what I said originally, that I'm asking the court to hold Mr. Shepard in contempt, reinforce the final orders that have been put in place by the court. I would like to be reimbursed the $6,000 that he still owes me in full and immediately. And then I'd also like to be reimbursed for the additional interest I have paid on that credit card debt, as well as reimbursed for the additional costs I've had to pay to bring him back to court to have the court enforce the orders yet again.
What additional costs are those?
I have paid 2 months now worth of interest, which the interest on his $6,000 balance is $82 a month.
Okay, that's I thought I was asking you about court costs.
That is going to be a total of $242 to come to court today.
All right, thank you. Ms. Basson, opening.
Yes, Your Honor. Miss O'Connell's motion for enforcement is simply just deficient on its face under 157.002 of the Texas Family Code. It is very vague as to the manner of noncompliance. Her section 7 of her pleading states that he failed to make payments as ordered and states a sum of $6,303. It does not have a breakdown of where the violations, what the violations were, the manner, how much has been paid, what was paid on what kind of debt. There's been no breakdown of that. The only relief that was requested outside of attorney's fees and attorney's fees and costs are the only relief requested in her pleading outside of the title for a motion for contempt. She does not actually ask for contempt in her pleading, and she does not ask for the additional interest that she's requesting today. And then we also have additional issues that I have included in my answer regarding Ms. O'Connell's violation of the prior agreed order in the suit.
Well, an answer. So, okay. So in an answer, you don't have any requested relief. And I see your answer. And if it was that they were supposed to agree on legal issues, there's already a motion ordering him to pay half the defense cost, right?
And we're simply asking for a reconsideration of that simply because there was a violation.
Well, you don't have the proper pleading, so I'm not going to consider that. You can't in an answer say she violated it. It's an answer. If you're talking about pleading defects, you have a pleading defect as well. But I think that, so I'm not going to reconsider an earlier order that was signed by, as it Judge De La Yata. I was looking at the order here a second.
That's correct.
Okay.
Further, my client lacks the ability to pay the $6,000. He does have a child support obligation that has not been modified after an additional child was born to to his family and that he is supporting. Therefore, he does have an increased child support amount. He's currently paying $885.94 a month in child support. He pays approximately $450 for the child's health insurance. And if you consider the additional child that he does have after the entry of that child support order, his payment would be $752.27.
Why would I consider that when there's no motion to modify? I mean, I'm not going to get into what his child support might be if an appropriate motion were filed, because that's not before me.
I'm simply asking, I'm giving you background information about his inability to pay and his current financial situation that renders him unable to pay the $6,000 in full. He has been paying monthly payments. And when I take into consideration, and what I've asked in my answer is for him to be able to continue to pay these monthly payments over time, instead of having to pay them all in one lump sum, since he does not have the ability to do that.
Well, Ms. O'Donnell, there are some, I appreciate the fact that you are representing yourself. I see that there's a long history with this case. I see that there's an order requiring him to pay the sixth or half of his defense costs. I think there are some deficiencies in your pleading. I don't believe, even if those were fixed, that I'd have the ability to award you the interest you've incurred. What I could do, and what seems is if render a judgment that will start bearing pre-judgment, post-judgment interest on the amounts he owes. But I don't know of any authority that would allow me to make him pay interest that you've incurred, which could be from a private loan and way above judgment interest. So I just don't think I'd have the authority to do that.
And that's understandable. And honestly, at this point, I mean, the total interest I have now paid on his portion of the debt is $164. That's not awful by any means, but I don't believe that it should be my responsibility moving forward to continue to pay interest on his debt, which is going to continue to be that every month. And
well, and I understand what you're saying, and I don't think I have the legal tools to make him pay the interest you're incurring. I could render a judgment, and there's judgment interest that would attach to that. I haven't looked it up lately. I think it's gone up. So, but you're pleading, I mean, you asked that he be held in contempt. I think there are some, we can move forward. I guess we can move forward. There's some issues with your pleading, but I'm just suggesting to everyone, including you, Ms. Bass, we could move forward. I could clarify the other order, or, I mean, at the end of the day, Ms. O'Donnell, even if your pleading were right, he's not going to get thrown in jail, which is one contempt. I mean, I could render a judgment if your pleading were correct. It seemed so, but I don't think your pleading is correct. So I'm asking Ms. Bass, we can go forward, she can refile, and we'll be in the same place, or do we want to try to move forward and just with a judgment?
My client doesn't have the ability to pay, and it seems that Ms. O'Donnell is going to continue to file these enforcement actions even after a month or two where he is making payments toward his debt. And so and then she's asking for attorney's fees and court costs when he barely has any ability. He's had to borrow money.
I hear what you're saying.
I would rather just reset it, and we both can amend our pleadings and come to court and have all of our pleadings in order.
Even if he doesn't have the ability to pay right now, Ms. Bass, you agree that he's been ordered to pay it. He's not going to get out of the debt, right?
No, he's just asking to be able to continue paying on a monthly basis as he's been doing since the last hearing. And he has paid off the other debts that she has listed in her pleading. He just has that legal bill it's outstanding. So
I don't think you're hearing what I'm saying. That's probably true. I haven't heard the evidence. Even if he doesn't have the ability to pay, I'm not going to wipe out the debt. The most I could do is enter a judgment. And it would, and then if y'all want to work out a payment schedule, but she could then move forward with trying to enforce a judgment. And I'm not here to give you legal advice, but Ms. O'Donnell, so.
Can I say something?
Yes.
I would be perfectly fine with a payment plan. I have been perfectly fine with a payment plan since September of last year when the orders were originally put into place. The problem is the first payment plan I offered at $500 a month, which also, mind you, had you accepted that payment plan offer, we would not even be here today because that $6,000 would be paid in full. When that plan was ignored, I offered a $300 a month payment plan. That was ignored, never responded from either Ms. Bass or Mr. Shepard. I have offered multiple times. I gave your client the opportunity to propose to me a payment plan. And if we could agree on it, then we would not have to continue to come back to the court. He never proposed a payment plan. Your client made the decision on his own to begin paying $100 a month in April. That was not discussed with me. It was not agreed upon, neither verbally or in writing. And that $100 has gone towards so far to pay off the $753. That does not even take into account the $6,000 yet, of which he still owes $153. And yes, I am asking for additional relief because I'm having to represent myself in all these court cases because I paid the money for our son's attorney.
Okay, hold on. I can hear the evidence and I will. I will say part of the evidence and what I will ask is how much Mr. Shepard he's entitled to be represented by counsel, but whatever he's paying for. So if we want to go forward with the evidence, I will do that. But at the end of the day, I think, probably all I could do today is render a judgment. Do you all want to talk and see if you can come up with a pay? And the judgment is bearing interest. So the longer he doesn't pay it, the more he's going to have to pay. Do you all want to talk or do we want to move forward with the evidence?
And I believe that we should simply either talk or, hear this at another day when.
Well, that's what I've just asked you. Those are the two. Well, we're not going to hear it for another date. There's not a motion for continuance. You all announced ready. So do you want me to move forward with the evidence or do you all want to talk for a minute? Those are the two options on the table.
I would love to have an opportunity to talk with Ms. O'Donnell.
Ms. O'Donnell, do you want to do that or do you want to move forward with the evidence?
I'd like to move forward. I've offered many times the option to discuss payment plans and have been ignored.
All right. Then Ms. O'Donnell, call your first witness. Go ahead. Who's your first witness?
I'd like to call Mr. Shepard, please.
Mr. Shepard, if you would raise your right hand.
Okay, Mr. Shepard, what property is in your name?
None.
So your truck is not in your name, your house is not in your name, credit cards are not in your name, you have absolutely nothing in your name.
No, I don't own my home. I don't have a truck title.
Okay. Do you have credit cards that are in your name?
I have a couple.
Do you have a bank account that your name is on?
Yes, I have a checking account.
Okay. And what all have you done to try to get the funds to pay me back?
I don't have credit available to me. I don't have anything I can leverage sell. I don't have a mortgage to get a second mortgage or anything.
Have you tried borrowing money?
Yes.
Have you tried taking a cash advance against a credit card?
Yes.
Okay, so you've exhausted every possible outlet there is on this planet to be able to reimburse me?
I have tried. I'm giving you what I can afford to pay you out of my paycheck.
Okay.
In addition to the child support and the health insurance.
Okay. Which the health insurance, though, we did determine at last hearing that the amount that comes out of your paycheck is actually for your entire family of like 6. It's not just Griffin.
I'm going to object to leading.
He's allowed to lead an adverse witness overruled. You may answer that, Mr. Shepard.
What was it? Please repeat the question.
So the amount that comes out of your paychecks for the monthly health insurance costs, that's for your entire family. That is not $450 a month is not just Griffin at 16 years old.
No, but the rest of my family has dual insurance. I was required to have insurance. So when I got it, it was the same cost to add the rest of my family to it as it was to have Griffin on it.
Okay.
Because my other children are covered under other insurance.
Hold on, let me ask. Other insurance is available to you? What other insurance cover your other children?
I have 2 stepchildren and then a younger son as well. The stepchildren are covered under their father's health insurance.
And
as
how's
well.
the younger child covered?
The other child is covered under my insurance as well.
Okay. So in your efforts to obtain the money to reimburse me, You've also managed, though, to continue to pay for legal representation for yourself. Is that correct?
I have not paid for the legal representation for myself.
Who has paid for your legal representation?
I mean, I'm not sure if that's you're really at liberty to know that information. But
I'm
it's
the one who gets to decide that. And yes, she can ask you that question.
It has been my wife through her business and my mother.
Okay, so has your wife not been able to provide you the money to pay your court-ordered reimbursement when she's still paying for your legal representation? So your wife, let me ask you this. Is your wife choosing to pay your legal representation to continue to fight me in this case instead of assisting you with the funds to pay your court-ordered reimbursement?
I'm going to speculation.
Oh, if he knows, he can answer it. Overruled.
The decision was made to protect our family.
Okay, and you believe that by not following court's orders, that's protecting your family?
Your original filing, you left it as an open-ended checkbook. Your request was to pay half of whatever costs you incurred. So I needed legal representation to protect myself and my family from the open checkbook.
Okay, well, let me remind you, and if you need to, the original motion and the orders modifying the parent-child relationship are on file with the court, and I do believe you have access to them. It specifically states that you are to reimburse me $6,000. It does not state there is an open-ended checkbook. It does not state for future legal defense costs of Griffin. It specifically states $6,000.
Correct.
It's point blank. If there's no open-ended, there's no gray area. It specifically states the amount and does not say, and any future legal defense costs.
That was not in your original filing.
And I'm going to check, there's been no questions asked. It's simply a testimony by opposing party.
Sustain.
I'm trying to phrase this as a question. I don't know how to put it as a question. But basically it just goes back to you and or your spouse funding your legal counsel, but not being willing to do the same for our son.
Object to the form, and it seems like testimony by opposing counsel.
Overruled.
I mean, other than, yeah, Your Honor, honestly, at this point, I've asked him, I think everything I need to ask him. I do have some other information I would like to just enter into.
Well, hold on. There's a process. Now I give Ms. Bass an opportunity to ask him questions, and then I'll come back to you. Ms. Bass, do you have questions for your client?
So it's your testimony today that you have exhausted all available outlets to pay the $6,000 to Ms. O'Donnell for the attorney's fees.
That's correct. Yes.
And do you believe that the amount of the $100 that you've been paying a month, is that the maximum amount that you could pay her a month?
Right now, yes. I mean, I can maybe squeeze a little bit more, 150 a month, but yes, 100 a month is where I'm at.
Okay. In the prior negotiations for a payment plan, would you have been able to make a $500 a month payment towards those attorney's fees?
No, and she had rejected our offer.
Okay. And what was our offer?
Our offer was to continue to pay the $100 a month. And then once my child support debt was satisfied in, a year and a half, 2 years, when he turns 18 or that debt is satisfied, to continue to pay that $885 a month for about 3 or 4 more months until it was paid. The remaining debt was paid, and she rejected that.
Okay. And are you asking the court to either render a judgment or allow you to continue to pay those monthly child support, those monthly payments towards the attorney's fees until that debt is paid off?
That's what I'd like to continue doing what I was doing. the
Okay.
best I could.
Okay. And to date, how much have you paid to Ms. O'Donnell since April?
$600, $50 biweekly.
Okay.
And she will receive another $50 payment tomorrow when I'm paid.
Okay. All right. I have no further questions.
Ms. O'Donnell, do you have any further questions for Mr. Spencer?
For
For Mr. Shepherd.
okay, sorry.
Sorry.
Yes, I actually do have a couple quick questions. Mr. Shepherd, at this point, how much do you pay in child support per month?
About 880 something. Over $400 biweekly comes out of my paycheck. About 410 or so, 420.
Okay. And then as far as the current child support arrears, what is that balance?
I'm going to object to relevance.
What is the relevance of that, Ms. O'Donnell, to this action that is before me today?
The relevance is he's when he was just speaking with her, when he was answering questions for his attorney, he said that once his child support obligation is paid off, a few months after Griffin turns 18, that he will then at that point have more money to be able to pay me. The fact of the matter is right now his arrears are currently at $6,900. Child support does not end necessarily at 18. It ends either when the child turns 18 or when he graduates from grade school, which that comes after he turns 18. And based on the arrears, that would leave you at 7.7 months to pay it off after the
Okay, that's not a question. You've made your point. You can testify. That doesn't really help.
Okay. And then my only last question for Mr. Shepherd is what is the hourly cost that you're having to pay your attorney to continue to represent you? What is the hourly rate?
Where?
You're unaware?
I have a retainer.
What was the amount of the retainer?
What was your retainer?
I'm sorry, you cut out.
How much was your retainer?
5,000.
And how much is left of that retainer?
I'm unaware at the moment. Not much.
And so if we continue to have to move forward with this, you're going to have to then provide another retainer to Ms. Bass because your current retainer is almost exhausted?
Would appear so, yes.
So wouldn't it make more sense instead of paying that retainer to Ms. Bass to provide that to me to pay your court ordered debt so that this situation can be done?
I'm going to object to speculation.
Overruled.
Would it make more sense that instead of you or your wife paying another retainer, that you take care of your debt so that no further judgments or interest or anything goes towards you or towards me?
The monies that have been paid in for attorneys have been provided by other people, not myself. They, while I understand where you're coming from and what you're saying or what you're angling, again, I have been making payments and trying to make payments, and you could accept the payments and the fact that I'm trying to honor the debt and do it. I just can't do it by your terms. But I am trying to make good.
And Mr. Shepherd, I appreciate your $100 a month. I do. Unfortunately, your $100 a month is hardly covering the interest.
I'm going to object to testimony by the opposing counsel or both opposing
It's
parties.
not, you must ask a question. You'll have a chance to testify. Do you have any questions for Mr. Shepherd?
I have one more question. Yes. So when I initially asked you who was paying your attorney's fees, you mentioned that your wife. Is that correct?
She has been one person that has donated money for it.
Okay. So then you just now, in response to another question I asked, you mentioned there are other people who have donated to your attorney's fees.
And I had answered that earlier. I said, my wife and my mother.
Your wife and your mother. Okay. So your wife and your mother, are those the only two that are paying your attorney's fees?
At this time, yes.
Okay. So have you asked your mother to maybe help with paying off this debt instead of paying for attorney's fees?
Yes.
And your mother okay. I'm done, Your Honor. That's it. Thank you. I appreciate it.
Ms. Bass, any further questions?
And your mother is unwilling to help you with the $6,000 debt?
Correct.
Does she have the ability, or does your wife or your mother have the ability to pay a $6,000 in attorney's fees at this moment?
No.
And do you have any other way to make that $6,000 payment in full at this moment?
No.
And have you had the ability to make that $6,000 payment since it was ordered that you pay that amount back in March? Okay, I have no further questions.
Ms. O'Donnell, do you have any further evidence?
Actually, I do actually have just a couple more questions for Mr. Shepherd, and then I'll be done.
Okay.
Mr. Shepherd, were the orders requiring you or ordering you to pay me the $6,000? Were those put into place September of last year?
Yes. I don't know the exact date off the top of my head, but yes, around that time.
September 18th, 2022. Does that sound about right?
Close enough. Yes. I'm not going to split hairs over a day.
Okay. And so you were aware at that time that you were being ordered to pay me $6,000. When did your monthly payment of $100 begin?
After we appealed the ruling.
Okay. So what month and year did your payments begin? April-ish, maybe May. Okay. So how many months did you have from when the original orders were put into place to when you decided to start making a monthly payment of $100? How many months was that payments could have been made?
6 months, maybe.
September to April?
6, 7 months, yes.
Okay. And then it was also stated earlier that the original orders regarding child support didn't take into consideration you had another child, but Brantley was born. Was Brantley born before our orders were put into place ordering child support in this reimbursement?
Shelby, the situation was
I asked you a question, Mr. Shepherd. Was Brantley born prior to our orders being put into place?
Which orders are you talking about?
The orders modifying the parent-child relationship from September of 2022. When the court ordered him to
just ask him, was Brantley born before September of 2022?
Was Brantley born before September of 2022?
Yes.
Okay. I have no further questions. I rest.
All right. Do you have any further evidence? Ms. O'Donnell, do you have any further evidence?
I do have evidence. I do have exhibits that I'd like to enter into court.
Do you have more than one monitor?
I do.
Pull up the exhibit you want to see on the second monitor, go back to Zoom, and at the bottom, it will have an icon that says share screen. And you click on that.
Okay.
I would object to any of the evidence if it wasn't attached to the motion for her contempt. I have not received any of those exhibits prior.
Is there discovery? Are you required to receive them before a hearing?
I mean, there's 194.4 just disclosures of this is a final hearing on a motion for contempt.
Do disclosures apply to a motion for contempt?
I believe it's a final hearing.
Well, I haven't seen what the exhibits are, so
I have. Yeah,
I don't think in a motion, disclosures don't require you to put forward all your exhibits, do they, Ms. Bass?
They just ask for a list just for you to have some kind of knowledge of what will be entered. And I
I
haven't.
guess we both need to pull out the rules and look at them because I'm aware of witnesses and experts, but maybe I'm wrong. Didn't these just change? The rules for disclosure just change as relate to family law cases and don't read on September 1st.
It's
Ms.
my
Bernstein, can you look that up while I'm here doing this?
It's my understanding that the 194.2 rules changed so that initial disclosures are not mandatory for family law cases now, but that the pretrial disclosures were not amended.
What pretrial disclosures are you talking about?
Under 194.4, it states that before you go to trial, that you just have to identify each document or exhibit that you might offer in trial.
194 point, I'm looking in addition. Okay, I think you're right. Time for pretrial disclosures. All right. Did you provide, Ms. O'Donnell, did you provide Ms. Bass any of these documents or a list of the documents you were going to use?
No, ma'am. I uploaded it all to the box this morning before the hearing.
What is it you're trying to offer?
I mean, honestly, given the fact that, you know, his argument is that he just simply can't afford it. I mean,
well, hold on. Has anybody done disclosures in this case, Ms. Bass? Did you? Because this
no.
Did he? I mean,
No.
Has anybody done disclosures?
I didn't have any exhibits to present. So I didn't do any for this hearing, but I didn't have any exhibits that I was wanting to present.
Well, I guess this says other than for impeachment, so I guess I have to know what I don't think she has to provide it to you if it's for impeachment under 194.4. What is it you're trying to show, Ms. O'Donnell?
A few items, which you have access to just being in the court, but there's the motion for a new trial that Mr. Shepard's attorney filed that was denied.
Yeah, I've reviewed the court's file, and that's
okay,
the court's file.
Okay, and then
ask me, hold on. Let's don't talk at the same time, please. You could ask me to take judicial notice of the file, which I've already been looking at.
yes, ma'am. So yes, I would like for you to take judicial notice for the motion for new trial, as well as the order denying the motion.
So noted.
I'd like for you to take judicial notice of the order of enforcement.
Yes.
I would also like for you to take judicial notice of the most recent order that the court put in place denying Mr. Shepard's motion for modification. That particular motion was asking the court to take that $6,000 and divide it up amongst his child support obligation payments. I'd also like the court to take judicial notice of the emails, which is Exhibit D. Those are all the emails back and forth that I've sent to Mr. Shepard and his attorney offering payment plans.
Those are by way of settlement, Nick. I'm not going to hear that.
Okay. Exhibit G shows the Venmo payments he's made. And then Exhibit H.
Do we have, I don't hear any disagreement that he's paid $600. Do we, Ms. Bass?
No.
Okay. So.
And then Exhibit H that from Walters Gilbreth law firm, Mrs. Bass law firm, that shows what the retainers amounts are and the hourly for an associate attorney. So it just shows what he's paying instead of.
Is that something you got off?
I got it off their website.
Yeah, that's not.
Doesn't hold up. Okay, that's fine. That's fine. I mean, honestly, at this point, I personally cannot afford to continue to pay his debt. I cannot afford to pay the interest on top of his debt. I am sitting here representing myself in every
Do
single,
you want to testify? If you want to testify, I need to swear you in.
Sure.
Or
Yes.
if you're making argument, represent, okay, raise your right hand. Proceed.
I am now accruing debt every single month on top of his debt because he has not paid me. As I mentioned earlier, had he agreed to $500 per month over a year ago, this debt would be paid in full. We would not be here today. I am now being charged $82 a month in interest on just his portion alone. I have paid off almost $4,000 of my $6,000. So my interest is lower. I am not Mr. Shepard's financial institution. I do not need to be responsible for for what he owes. It is not my debt. I have followed all of the court's orders. I have followed everything that's been put in place. I have even asked Mr. Shepard on multiple occasions to offer up a proposed payment plan. And as long as we could agree to it, we would not have to bring the court back into this to enforce it. Mr. Shepard has ignored every single email and proposal I have provided him. He chose on his own accord to begin making a payment of $100 a month starting in April, 7 months after the original orders were put in place. That is not a payment plan I agreed to, not verbally, not in writing. It was not a plan that was discussed. He just started making that payment on his own accord without any discussion. I cannot afford to continue to come to court. I cannot do it. I have 2 children that I'm taking care of. I am now solely responsible for our son because our son does not reside with Mr. Shepard at all anymore and has not in 2 years. I am his sole caretaker. And yet I am being forced to pay more money on Mr. Shepard's debt. I'm being forced to pay more money out of pocket to continue to come to court because Mr. Shepard will not comply with the orders. And these are not financial burdens I can take on. I cannot do that. I have 2 children I am raising and taking care of. And with inflation and everything else going on, it is getting tighter by the day. So I can understand Mr. Shepard's dilemma here, but Mr. Shepard is also continuing to pay for counsel.
All right. Do you have anything further? I understand, and I understand. Do you have anything further?
I'm done, Your Honor.
Ms. Bass, do you have any questions for Ms. O'Donnell?
No.
All right. As I said at the beginning of this hearing, well, you have no other evidence, Ms. O'Donnell.
No, ma'am.
Okay. As I said at the beginning of this hearing, there are very limited things I can do. Just like if you don't pay your credit card debt, people can't. The only thing I can do is render a judgment for the amount he owes, which I will do. I, however, find based on the testimony that I deny Mr. Shepard's affirmative defense that he had didn't have the ability to borrow funds because his own testimony shows he had the ability to borrow funds to pay for counsel. So that affirmative defense is denied. I will render a judgment for is $6,000. Well, I'll go back and look at the order. We'll give him credit for 600. I'll figure out exactly how much. Ms. Bass, do you know if it's 600? I'm looking at the order. The order.
I thought that it was the 700, but if it's the 600 that we agreed to, then that is what he's paid. And so I guess it would be the 6,000. And then
I am not. It's 600. I'm not gonna fight
Okay.
that.
So you're pleading with okay. So he was ordered in March of 2013 to pay $360 by March 31st. He was ordered to pay $360. He was ordered to pay plus a $393. That plus this, we all agree that half of the child's and that he hasn't paid anything else. That's all. I will find that that's all he's paid. So that is, in addition to half the defense funds, that was $753, of which he's paid $600. So he still owes $153 for the expenses related to the transfer fee paid by Ms. O'Donnell and the court costs that were found, paid by Ms. O'Donnell, that were found in the March 29th, 2023 order. Does everybody agree that half of the child's defense fund is $6,000?
Yes.
Yes.
So I'm going to render a judgment for $6,153. I find that it bears pre-judgment interest dating back from March 29th, 2023, and post-judgment interest at the rate set forward in the statutes. Ms. O'Donnell, I hear what you're saying, and under the state of the pleadings, that's all I can do. So there's a judgment, and it can be enforced just like any other judgment. And because there were no other than the dates that he was supposed to pay. Well, I find that he did not pay by March 31st, 2023, $363, and by April 28th, 2023, $393. So he is in contempt for those specific orders. I find that he has not paid the 50% of the fees for the defense counsel, which we all agree is $6,000. So I'm entering a judgment in the amount of $6,153. It bears interest. Mr. Shepard, I hear what you're saying, but I do sign. It's just going to continue to bear interest until it gets paid. So, and that's all I can do, Ms. O'Donnell, on the state of the pleadings. But I do find that the affirmative defense set forward in his answer, I deny, because he was able to borrow money for counsel. So,
And Your Honor, is there no relief for the money I've had to spend to come back to court yet again?
I kept asking you if there was any evidence. You didn't offer any evidence. I asked you twice, so the evidence is closed, so there's not. And I appreciate what you're doing. Look, I understand you want to get paid. There are limited, even if you had a lawyer, I doubt you would have had, well, you might have gotten any evidence about what you paid. But I don't think there's much, if anything else, that could have been done about that. All right. I'm going to ask my staff attorney to draft the order.
Melissa Granger here on behalf of Maya Coria, who is also present.
My name is Desmond Mayfield Jr. On behalf of myself, respondent. Pro se litigant.
Well, hold on, Mr. Daniels. Aren't you on that case? And you have to unmute yourself.
No, I dismissed him. I don't know why he's here.
Well, he's not dismissed until I sign an order.
Okay.
Yes, Your Honor, I'm Tim Daniel, and that's true. I'm here because I have not been dismissed at this point, and we are asking you to grant our motion. However, until then, I am here representing Mr. Fields.
Mr. Fields, I'm going to say to you that the local rules do not allow an attorney to withdraw until all outstanding orders have been entered. Y'all are here to enter an order from a hearing I had on August the 30th. So, Mr. Fields, I suggest that you would be well served to let Mr. Daniels tell me what, if anything, is wrong with the form of the order.
May I speak?
Yes.
I would have myself rather speak than anyone else today.
All right, you do so at your own peril, because this is a matter of just making sure that the order says what I ordered. Then, because you've requested that, I'm going to let you respond, and I'm going to make you go to the same rules that I make lawyers follow. So Ms. Granger is going to, so we're going to start with Ms. Granger. You have temporary orders that have been filed. Mr. Fields, tell me what's wrong. Start with what page do we need to go to with what's wrong with the order? Start with the first page in which you have a disagreement.
The first page would be the home state of Texas. That's the main issue of what's going on today. The child pertaining to this matter, home state, will not be Texas for multiple reasons.
Okay, that is overruled, because that was not what I found during our hearing. What's the next problem? What's the next page you have an issue with, Mr. Fields?
The next page would be where page 28 at the very, very bottom. So where,
28. Okay, let me get there.
I'm sorry, it's the second paragraph on page 28.
Hold on. Second paragraph that says you are ordered to take a divorced father's course of your choice.
Yes, I was never married.
You were never what?
I was never married. Your Honor, I was never married.
Ms. Granger, I ordered that they take a cooperative parenting class, not a divorced father's course. So you need
Your
to.
Honor, yes, you're then the cooperative parenting classes in the preceding paragraph. He was also, to my recollection, ordered to take a divorced father's course of his choice. If the court wants to go ahead and strike that section, that's fine with me. I have no issue with that. I can make the change, or
Okay, you will take out that paragraph because my docket notes don't say that I said anything about divorced father, so we can take that paragraph out. Mr. Fields, what else do you have?
I also have another.
With this order, I want to know anything else that's wrong with this order.
Order, ma'am, in regards to the home state. My father for the pleaded jurisdiction, and as well as it's an ongoing custody case regarding this child in Indiana. Indiana would like to confer with you, depending on things that's going on. And as in the UCCJEA in section 110, second paragraph, it states that court may not confer within a sister state when they're trying to confer and have a UCCJEA conversation.
I don't that wasn't requested of me on the time of the hearing. I've already signed an order denying that your plea to the jurisdiction on September the 8th. So if there's something in Indiana and the Indiana court wants to reach out to me, that's fine. But that was not a request that was made, nor do I recall the evidence at the time would lead me to do that.
Yes, sir, I'm aware. That's why I would like to speak myself instead of anyone else, because that was presented.
Anything else about the order?
No, Your Honor.
Okay. Do you have any issues with the income withholding order that has been prepared?
Yes, I submitted pay stubs to my attorney. I think he showed Ms. Granger, they discussed about it. I don't know what happened with that. And me personally, I feel like it's a quite a bit high for $650 a month because all was coming out of my check as far as insurance regarding the child and union dues as well, which leaves me with very little to none.
Well, my docket notes indicate that I issued non-guideline child support because due to the cost of travel, and that I made my determination of $650 per month to begin September 1st based on the evidence that was presented. So that's overruled. This income withholding order says $650 a month, so I'm going to sign it that way because that was the order.
Yes, Sean. And another thing, that's another problem where you just said based on travel. In the court order, you stated that travel be split between me and the mother. So if I'm paying travel expenses already within the $650, I have to pay extra travel expenses.
Yep, you have to pay half the transportation to and from the residence.
But it's already incorporated into the $650.
Yeah, because my docket notes indicates that your child support would have been higher than $650, but for the travel.
Okay, then so half would be the travel cost.
I ordered $650 in light of whatever the travel costs were. And you have to pay, I don't know, Ms. Granger, how does the order issued that they each have to do half the transportation?
half. It was half, Your Honor. It was each pay 50%.
For the child to travel, and the child too little to travel by him or herself?
For the order was for 50% to each party of what it cost Mr. Fields to exercise his possession and access.
Okay.
That was what was rendered.
That's right.
So
Fields, if you get an airline ticket, you send it to her and she has to pay you half of it. But you still have to pay $650.
right. So that's what posed another question. So I'm paying half of his travel costs to Indiana and back to Texas as well, correct?
Yeah, both ways. Half, yeah.
Okay, so I just want to get this clear. You said you overruled anything regarding the child's home state because the PKPA really explains that Texas erasively took jurisdiction over this child.
I found that the child had been Texas was the home state of the child, and I overruled your plea to the jurisdiction that you presented to me on August the 30th.
I just wanted to get everything on file because I object that and this would be hurting the appeal. So I just wanted to make sure that was heard.
All right. Ms. Granger, if you would revise that order and send it to me.
I just revised it, Your Honor, and it has been sent with my signature as to form and to the submission email.
Thank you. Anything else?
If Mr. Daniel's motion to withdraw is going to be granted, I would just like the order to reflect Mr. Fields' email address and that there are outstanding discovery requests due on November 11th.
Well, that's not set before me. I don't have a motion to withdraw set. If you all work it out and you want to send it to me by agreement, that's fine, but it's not set today. Is it?
Okay, Your Honor, I
Daniel?
wasn't sure if the court was going to consider that today.
Mr. Daniel, is it?
It's been submitted that Mr. Fields has asked us to withdraw, but I don't believe it's made it to your queue yet. Absolutely. I've asked a paralegal to try to expedite that, but just for Mr. Fields' wishes. He's not wanted me to speak today, so I've not spoken today, and
Okay.
I don't know how I can continue representing him.
Mr. Fields, well, once these orders are entered, if you were only hired to represent him on this matter, I think I don't know what your contract says. I think your representation would be over. If not, so this is I'm only signing a temporary order, right? It's an ongoing.
Correct.
Mr. Fields, Mr. Daniel is your attorney of record until and unless there is an order of withdrawal. Ms. Granger is objecting to the form of the order and that it needs your email address and it needs to specify when your discovery is done. If everybody agrees to that order, I will sign it, but it has to be agreed to by Mr. Daniel, Ms. Granger, and Mr. Fields. Does everyone understand?
Yes, and I believe it conforms to Ms. Granger's requirements. Is Ms. Granger, am I incorrect about that? I believe it has the outstanding discovery required and his email address on it. If I'm wrong about that, then we'll certainly change it. But I believe I looked at it today and it seemed to be in order, but tell me if I'm wrong.
I am happy to discuss that with you outside of this hearing, Mr. Daniel. I do believe it does not contain those two things.
Okay, well, we'll definitely change that. And do I understand you, Mr. Fields, that you are asking me to withdraw? And so it seems to me that we have agreement on all of that.
Unless everybody, hold on, everybody has to sign the order. If you can't get everyone's signature on the order, you need to set it, Mr. Daniel.
Okay, absolutely.
Yeah, yes.
Anything further?
Nothing for my part, Your Honor.
Good afternoon, Your Honor.
Okay.
Allison Falk on behalf of Ryan Crater.
Lloyd Ward here on behalf of Laura Crater, Your Honor. And Your Honor, I'd like to apologize. I'm in Paris, France right now, so I'm not wearing suit and tie. And that's
what I was going to get after you about, because this is a virtual courtroom. So, all right. So, Mr. Ward, there was an order signed disqualifying you.
Well,
not from this hearing. I'm sorry, not from this hearing, Your Honor. This was a separate proceeding. That was in regard to the spousal support issue, Your Honor.
Ms. Falk.
Yes, Your Honor. Since we appeared before you, we've been able to settle all other matters in mediation. And so this is, other than the form of those orders, that modification suit and the spousal maintenance suit, this is the only other issue we need to resolve, which is the entry of the enforcement order that you rendered on August 2nd. We filed a motion to enter on September 12th, and I've emailed Word copies to Ms. Chambers of the clean and redlined versions of the order in dispute.
All right. I have those here, and I'll pull up the red line orders.
Yeah, it shows up a little in a strange way, so it's easier to look at on the PDF, and which I have highlighted as well.
Why don't you just let's share screen and you pull that up, and Mr. Ward can tell me page by page what we need to take up.
Okay, so
wait. I think she had asked for. Do you want me to do that, or do you want her to do that, Your Honor?
She said she has a red line copy. I mean, she drafted the order, so I was going to have her pull up her order, and then you tell me page by page what's wrong with it.
Actually, Your Honor, Mr. Ward drafted the initial order. We sent revisions, and we never got actual feedback from Mr. Ward about our revisions. So basically, what the court has in a clean version is what we believe ought to be submitted. We've never heard back from Mr. Ward about what's wrong with that.
No.
So I have, okay.
Yeah, if we want to get into this, I sent a letter to the court with 4 different times requesting she call me, and she never bothered to call me. So if there's a communication issue, it's in a September 12th letter with the emails attached.
Well,
If we
I'm
want
here on a
discuss the order, we
motion
can do
to,
that.
I'm here
Right.
on a motion to enter. So we'll pull up her red line. I'm going to ask her to pull it up.
Mhm.
To be her red line of your order. And you're going to tell
Yes.
me what you do or don't agree with about every one of her changes. And then I'll make rulings.
Okay. The first one is on page 2, Your Honor, of the proposed order. She redlined where I specifically put the court grants movement Laura Bryant Crater's motion for contempt as to the following portions of the agreed final decree divorce. Your Honor, as I'm sure you're aware, the courts have said that you have to set forth with specificity the exact portions of the order which were violated. I believe that language does that.
On page 2, okay. I need somebody to pull it up because I'm looking at a red line that doesn't say page, it comes to page 3.
I
So-
know, Your Honor. Hold on one second. Okay. These are the revisions I made to Mr. Ward's order. It's almost easier, like I said, to look at them cleanly, but
Well, then are you, if I look at them cleanly, if you can tell me, well, no.
I can, Your Honor. I can. This is Mr. Ward's clean order.
Well,
He
hold
would-
on. If we see Mr. Ward's clean order, then you're going to be able to go page by page and tell me what you want to add or subtract.
Yes, and it's really more to, I mean, that's why we submitted the Word ones, Your Honor. I'm sorry.
Well, the problem is, Ms. Falk, that we all need to be looking at the same document.
Can we look at my clean order and he can tell us what's wrong with it, since that's what we don't have a response to? And that's what our.
Your Honor, what we don't have a response to is the fact I sent one over, she redlined it. I sent her an email back, said her changes did not comply with requirements for contempt and asked her to call me 4 times and she never called. Therein lies the problem. And the emails are attached to the September 12th letter, Your Honor.
Your Honor, I needed to communicate with Mr. Ward in writing, and I did that repeatedly.
So let's pull up Mr. Ward's clean order and you will go page by page, Ms. Falk, and tell me what's wrong with it. That's typically how we do it. I mean, unless you're that red line. Well, so what is your suggestion? I mean.
Okay. All right. This is Mr. Ward's order. And I'm on page 2. This is something he added himself. I don't have a problem with that. These highlighted items on page 3 do not comply with the court's order, or they repeat themselves later.
That's 2 different things.
Mm-hmm.
Which paragraph do you say? The highlighted, let's see. So point out to me what portion, so you don't want the highlighted portion.
That's right, Your Honor. The court made different findings.
Does somebody have a transcript?
We do, yes.
Yes.
Okay. Can you see the transcript, Your Honor?
Mm-hmm.
Okay. So these are the only findings that were made.
All right, let's compare that to what the decree says.
The order?
Yeah, the order, sorry. Okay, so I'm sorry, I'm being slow. You don't want the first highlighted paragraph, or you do?
I just want the finding that the court made.
Your Honor, we believe that complies with what the court stated. If it doesn't, I'm sure the court will correct me, but I believe that does comply with what the court just said.
Well, Ms. Falk, what's wrong with that highlighted paragraph? He didn't, well, what you showed me a minute ago was as to an insurance trust, not life insurance policy. So show me in the transcript what it says about life insurance policy, because that's not what you just showed me.
Correct. The only thing it says about the insurance policy is that he did not provide her the notice of it within 30 days. It didn't say anything else about the life insurance policy.
It's been a long time, which is why I don't like to let these things go, but I don't recall whether there was, what the evidence showed that there was a life insurance policy in effect.
And as a refresher, Your Honor, if you, again, may or may not help refresh, but he actually purchased the policy 6 months after the date the decree was signed. And she was not the beneficiary of it. And it was for an amount of, I believe, $475,000. There was quite a bit of testimony on it.
Yeah, and I don't agree with that, Your Honor, but that's, at the end of the day, we are just trying to get an order that complies and moves on. And I didn't want it to say more than what was found.
Okay, but you just highlighted some, it's hard. This is really difficult. I wish I had pieces of paper, because the transcript, okay, says, in contempt for failing to give her a life insurance beneficiary designation within 30 days, because that's what the decree specifically says. So the highlighted paragraph says more than that, doesn't it?
Yes. The provision in the order says more than that.
Provision in the order says that he failed to purchase and maintain in full force and effect a life insurance policy. That's not what my finding says. Why do we need that paragraph, Mr. Ward?
Your Honor, I understand that if you go back, and again, I'm not going to do this, but if you read the entire transcripts, this was an hour-and-a-half hearing. In fact, he didn't have life insurance policy that was adequate to pay these. As a matter of fact, the court pointed out that it wasn't just the unpaid portion of the child support, but also included health insurance. And there was a disagreement between counsel and I as to what the amount of that policy was going to be or should have been. And again, I agree with what she just highlighted, does not say that. And it's been, I'm sure this court's had more than one hearing since this hearing was held. But the simple fact of the matter was, this was one where he had purchased the policy substantially after the divorce, about 6 months after the divorce. And we didn't have a copy of it. As a matter of fact, they had to give us a copy of it at the hearing, if that helps with any recollection. If you want it out, Your Honor, I think that the evidence was there. If the court doesn't believe that, if the court doesn't recall or doesn't believe that substantiates with what the court said,
I don't see what Ms. Falk has shown me does not justify that paragraph.
Okay.
If there's another portion of it, I don't recall, but the highlighted portion doesn't show that. It just says he didn't do it when he was supposed to.
Okay, the top portion of it, then I take it that's going to be struck. Correct, Your Honor?
All right, great. What about that? And what's the red portion?
That's actually something that Mr. Ward redlined on his own order without reviewing ours. So we don't disagree with it. I think it's
let's move on. We don't disagree with it.
Great.
What's the second purple highlight?
It's basically a restatement of, this is saying he did not complete the insurance trust, which the reason why it's highlighted is because it says it again down here. It does it twice. I don't think it needs to be in there twice. So that was just something that we had noted didn't need to be part of this order twice.
Mr. Ward, is there a reason we need to say it twice?
No, Your Honor, we can strike that.
Okay, great.
And
are you making notes or are you going to strike it as you go, Ms. Falk?
I'm making notes, Your Honor. This is on a PDF because, like I said, the versions that we got didn't match up with our Word version. So I have my clean version and then I have this PDF of his versions.
All right, go ahead.
And Ms. Sheldon mentioned she's making notes as well. I don't have record that the court is allowing Ms. Crater 15 days from the entry of the order to replead the claim she withdrew, or that the court granted special exceptions on. So we do want this litigation wrapped up. Again, there was not a finding of that.
Well, a special exception by definition allows someone to replead, doesn't it?
Yes, and she did.
What I'm saying, Your Honor, is it wasn't made part of the order. This is the final order in this case. So what is this going to close out our case when we sign this final order? Is what I'm saying. Are we keeping it open, waiting the 15 days?
Yeah, it was just part of the court's ruling, and it is in the transcripts, and counsel's aware of it.
It was your special exception, wasn't it, Ms. Falk?
Yes.
Right, and it was granted, and all I'm saying is, when are we cutting off that?
Why don't you just do a separate special, if you don't want it in here, then you have to do a separate special exception order.
Okay.
I mean, it was your special exception. So I'd prefer that it be in here. But it would have been better if we had done a separate special exception order in August rather than waiting till the middle of October.
Okay.
So why don't you just do a separate order on special exceptions? And if he hadn't repled in 30 days, then he hadn't repled.
Okay. Hold on. I think this is highlighted because it says it again on the back. Okay, I'm on page 5 now. And it's this first paragraph that we do not agree that the court ordered, requiring Dr. Crater to file documents with the court and all of that. That's not part of the court's enforcement order. And just to cut to the chase also, we've since mediated and that whole requirement has gone away, but I don't want my client required to do something he's not required to do.
Yeah, it has gone away, but as I'm sure the court's aware, in order for contempt order to ever have been enforceable, it has to provide the means by which one can relieve themselves of the contempt, which is what this does. And the court had found that he was in contempt for not doing it. Ergo, the remedy for that contempt is that he do it.
What do you mean it's gone away though?
We've modified it, Your Honor.
Yes,
We
Your
have
Honor.
filed a modification.
The mediated settlement agreement has been filed in the records of this cause, and it does away with this trust requirement, and it clarifies.
But okay, so that was subsequent to this order, right?
Right.
It was, yes, Your Honor. But the court didn't order Dr. Crater to do any of this.
Your Honor, for it to be a contempt order, it has to have a means by which the contempt order can relieve himself of contempt.
Show me in the transcript where I ordered him to do it.
You didn't, Your Honor, and
Then I'm
that's
not
the
going
whole
to put it in
thing.
there.
Then how does he relieve himself of the contempt?
Well, does it really matter since now you've done away with it?
No, but I'm just saying for purposes of drafting an order. I mean, I understand the court's point, but my only point is,
If you want to leave it in there, then I'm going to insist that you have another order that says subsequent to the date of this hearing, the parties have
Okay.
agreed to do away with this. And I get Ms. Falk's point. I don't want you to file another contempt on him between the date of this hearing. Y'all are making me realize I should have made you come back within 2 weeks to do a motion to enter.
Okay. We can remove it, Your Honor.
Remove it.
Thank you, Your Honor. And then the reason why I had this payment highlighted on page 4, now I see, is because on page 5, it restates that Dr. Crater is ordered to pay Miss Crater the $2,500. So again, we don't want 2 requirements that he pays $2,500. It's just the one.
Where's the other one? I only see one.
It's right here, and I wish I had multiple colors to highlight, but it's right here, the second to last paragraph.
Okay, where is it before?
It's on page 4 before.
That's in the findings, Your Honor. The second time is in the order where you made a finding that he was going to
Yeah,
have
that's
to pay
not an
it.
order language, Ms. Falk.
Yeah.
That's
Okay.
fine.
Okay.
So
Mhm.
that doesn't say he's ordered. So
Okay. The good news again, he's paid it. So we will clean up the.
Well, why don't we say, if it's paid, why don't y'all agree and say the receipt and sufficiency of which is acknowledged? So we avoid future.
Sure, I'm fine with that, Your Honor.
Okay, great.
Okay, great. So should we circulate a revised order and have that to you here shortly, Your Honor?
You should circulate it. Mr. Ward, I'm going to have her send it to you. You will have
Okay.
20, I want her to send it to you today. If I haven't heard from you by noon tomorrow, my time, I'm going to sign what she sends me.
Okay. You know, the only issue I have with that is the fact that I'm not going to be back in the United States until Wednesday of next week.
Yeah, so you have access to email?
Yes, ma'am, I do. I don't know that I can pull that up and read it, but I know I have access to my
Well, I'll tell you what.
iPad.
Well, then I want you to look at it. She's going to send it to you in the next
Okay.
hour, Ms. Falk. And I'm going to wait till noon Central Standard Time tomorrow.
Okay.
And if I don't hear, and if I get it from Ms. Falk and I've heard nothing from you by noon Central Standard Time, I'm going to sign it.
Yes, ma'am.
Thank you.
Thank you, Your Honor. May we